5 seconds to go. Start. In Shambhunath Mishra versus State of UP and others, reported in 1997 5 SCC 326, allegations of fabrication of record and misappropriation of public funds were made against the accused public servant. The court, while holding that sanction was not necessary in the facts of the case, reaffirmed that the Public Servants Act must be in furtherance of the performance of his official duties, and only if the act or omission is integral to the performance of the public duty, he would be entitled to protection under Section 197 CRPC. While stating so, the court elaborated on the objective behind the enactment of the provision and clarified that the protection of sanction is an assurance to an honest and sincere officer so that he can perform his public duty honestly and to the best of his ability. The threat of prosecution would demoralize them, and therefore the requirement of sanction by the competent authority or the appropriate government can serve as a shield only for such honest officers who carry out their duty with an aim to further public interest. The court also rightly cautioned that, however, such an immunity cannot be utilized by public servants to camouflage the commission of a crime under the supposed color of public office. This court's reasoning in State of Odisha and others versus Ganesh Chandra Jeev, reported in 2004-8 SCC 40, was further adopted in a few other landmark decisions. The court in Ganesh Chandra Jeev Supra considered the scope of the expression official duty and stated that the protective cover of the section must not be extended to every act or omission done by a public servant in service, but be restricted to only those acts or omissions which are done by a public servant in the discharge of his official duty. The scope can be widened further by also extending protection to those acts or omissions which are done in the purported exercise of official duty, that is, under the color of office, but not more. Dr. Arijit Pasayat, judge, went on to state that the protection given under Section 197 CRPC must not be viewed as limitless. This protection has certain limits and is available only when the alleged act done is reasonably connected with the discharge of his official duty and not merely a cloak for doing the objectionable act. However, if the public servant acted in excess of his official duty, but there exists a reasonable connection between the act and the performance of his official duty, the excess cannot be a sufficient ground to deprive him of the protection under Section 197 CRPC. Therefore, it was reiterated that it is the quality of the act which is important, and such an act must fall within the scope and range of the public servant's official duty. While there cannot be any universal rule to determine whether there exists a reasonable connection between the act done and the official duty, one safe and sure test in this regard would be to consider if the omission or neglect on part of the public servant to commit the act complained of could have made him answerable for a charge of dereliction of his official duty. If the answer to this question is in the affirmative, the protection under Section 197 CRPC can be granted, since there was every connection with the act complained of and the official duty of the public servant. The relevant observations are as follows. This protection has certain limits and is available only when the alleged act done by the public servant is reasonably connected with the discharge of his official duty and is not merely a cloak for doing the objectionable act. If in doing this official duty he acted in excess of his duty, but there is a reasonable connection between the act and the performance of the official duty, the excess will not be a sufficient ground to deprive the public servant of the protection. The question is not as to the nature of the offense, such as whether the alleged offense contained an element necessarily dependent upon the offender being a public servant, but whether it was committed by a public servant acting or purporting to act as such in the discharge of his official capacity. Before Section 197 can be invoked, it must be shown that the official concerned was accused of an offense alleged to have been committed by him while acting or purporting to act in the discharge of his official duties. It is not the duty which requires examination so much as the act, because the official act can be performed both in the discharge of the official duty as well as in dereliction of it. The act must fall within the scope and range of the official duties of the public servant concerned. It is the quality of the act which is important, and the protection of this section is available if the act falls within the scope and range of his official duty. There cannot be any universal rule to determine whether there is a reasonable connection between the act done and the official duty, nor is it possible to lay down any such rule. One safe and sure test in this regard would be to consider if the omission or neglect on the part of the public servant to commit the act complained of could have been made him answerable for a charge of dereliction of his official duty. If the answer to this question is in the affirmative, it may be said that such act was committed by the public servant while acting in the discharge of his official duty, and there was every connection with the act complained of and the official duty of the public servant. In Sankaran Moitra versus Sadhana Das and another, reported in 2006 for SCC 584, the appellant police officer was accused of killing the complainant's husband while carrying out a lathi charge near the polling booth on an election day, while the bench in its majority opinion had held that the appellant was acting in the discharge of his official duty. C.K. Thakkar, judge, in his minority opinion had stated that the act complained of had no nexus, reasonable connection or relevance to the official act or duty of such public servant and was otherwise illegal, unlawful, and high-handed. He went on to state that it is not only the power but the duty of the court to apply its mind to the factual situation before it. The courts must ensure that, on the one hand, the public servant is protected if the case is covered by Section 197 CRPC, and on the other hand, that appropriate action would be allowed to be taken if the provision is not attracted and the accused is trying to take undue advantage of the section under the guise of his position as a public servant. The relevant observations are as thus. From the aforesaid decisions, in my opinion, the law appears to be well settled. The primary object of the legislature behind Section 197 of the Code is to protect public officers who have acted in discharge of their duties or purported to act in discharge of such duties. Stop.